it should also be noted that a couple of things. If a merchant is dealing with a non-merchant, and a contract would otherwise need to be would need to sort of have some consideration, you may have a requirement for a writing for a contract that might not otherwise require a writing. What does that mean? All right. So the UCC does away with the consideration requirement with regards to sales or leases of goods, but modifications are changes in terms, right? And so if the person is a non-merchant, that has to be in writing as a way of sort of fairness, sort of dealing with the unequal sort of like usage of trade knowledge is something that the business or the merchant would have that the consumer may not necessarily have. So a notice would be required. In addition, if the modification would bring the contract otherwise within the statute of frauds, then that itself would also need to be put in writing, because the statute of frauds, as we're about to discuss, and as you may recall from Business Law 1, is a requirement that's codified in the UCC and therefore in most of the states, that certain types of contracts be in writing in order to be enforceable. So if you'll remember the different sort of categories of classifying contracts from Business Law 1, right? You can have a valid contract, void, voidable, or an unenforceable contract. You can make a contract that would be valid and it would therefore be unenforceable if it violates the statute of frauds. It's codified under UCC 2-201 sub 1 and 2A-201 sub 1, right? So, and it relates specifically for goods priced at $500 or more, is a specific trigger that requires the use of a writing in order to memorialize that contract, in order for that contract to be enforceable. So sales of goods priced at $500 or more and lease contracts requiring payments of $1,000 or more, in each of those circumstances, those contracts have to be in writing in order to satisfy the statute of frauds, and that's UCC 2-201 and 2A-201, right? And so it's worthwhile here to discuss the sufficiency of the writing that the statute of frauds requires. In this case, the writing is sufficient if it indicates that the parties intended to form a contract and it is signed by the party against whom enforcement is sought. All right? So as long as those two requirements are met, and in addition, in the case of a merchant transaction, all right, there's a special rule that simply says that they can satisfy the statute of frauds if, after an oral agreement, one of the merchants sends the other a written confirmation within a reasonable amount of time. So that will also satisfy the statute of frauds requirement. And it's worthwhile pointing out that the same exceptions to this writing requirement apply, as you may have learned in Business Law 1 with regard to the statute of frauds. And those are goods that are specially manufactured, right? If they are specially manufactured goods, then they will waive the requirement, right? Because they are unique for a particular lessee or a particular buyer. They're not suitable for resale to others, and the process of manufacture has been substantially started, right? Also, in the case where the other party admits to an oral contract, and particularly where there's been partial performance of a contract, payment has been made on the one side and manufacture has begun on the other. All right, but those are exceptions, and not the general rule is that if it fits into those categories discussed previously, right? Over 500 for goods sales and over 1,000 for good leases, then it must be in writing to satisfy the statute of frauds. Now, the next segment deals with parole evidence, or what's known as the parole evidence rule. Now, P-A-R-O-L, parole, right? In this sense, it is referring to anything that is extrinsic, right? That is outside of the contract, right? That provides some information, evidence, right, of what that contract means or what was intended, right? Where a contract is fully integrated, meaning that it is intended to reflect everything that the parties agreed to, parole evidence is generally excluded from being offered to indicate the terms of the contract, to indicate what they may have meant, right? There are some exceptions that you may recall from business law 1. And the most important of these is the one that turns on whether the contract is fully integrated. If, for example, the final writing indicates some but not all of the terms that needed to be agreed to, then that contract would not be regarded as fully integrated, and as a result, that contract would be subject to interpretation utilizing parole evidence, these other things that can come in, these external statements, perhaps other writings, perhaps testimony about what was said, what was done, perhaps, although it should be, objective evidence still, because we're still dealing with the objective theory of contracts, meaning that what was said, what was done, the actions that the parties took have to take precedence over subjective things like how the parties felt or what they perceived, which is another type of evidence, right? But this extrinsic parole evidence can be admitted in that case, and it comes in several types with regard to the UCC that are dealt with. Course of dealing and usage of trade are each terms that you should be familiar with. The course of dealing indicates how the parties have interacted with one another in a sequence, right, of their history of working with one another. And that is dealt with under UCC 1-303B, and it's restricted to the sequence of contact between the parties in their transactions prior to this current agreement, right? Usage of trade. Also, course of dealing is also relevant in associating the meaning of the parties' general agreement, right? So some actions that take place in the process of their interacting with one another, right, may give definition to the terms that are actually written there, and to that extent it can be used. Usage of trade is a practice that is adopted across an industry that should indicate how a typical deal between merchants in this industry might go, and so it is used as evidence to justify the expectations of the parties, right, that will be imposed on the transaction, right? So if in my particular industry it is typical to have a 90-day billing cycle, right, and I'm being sued on arrears based on a 60-day billing cycle, right? And when adjusted, I say, oh, I'm in our industry, it's generally 90 days, right? That might, and if it's unstated and that's not a fully integrated agreement, right, that may impact how that case is looked at, right? That's one example of how usage of trade might be used, as opposed to how course of dealing is going to be used, which might, look more at how that payment arrangement has worked. If I typically had been paying on 60 days and he's imposed this 60-day requirement as a result, and it's not stated in the agreement, then arrears that are between 60 and 90 days, maybe it's arguable that should be actionable if I'm behind, right? But if we're talking about this particular transaction, then that's actually not course of dealing. That's known as course of performance, all right? And so this type of evidence refers to the sequence of conducts that are in play with regard to that particular transaction between those particular parties, assuming that it's executory, for some period and the parties have